The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 896, and it is coming to you on Monday the 9th of April, 2018. On this program, I will speak to you on the topic, the granting of bail. But before getting into the topic, I would like to make a few preliminary comments. As usual, I would like to send my deepest condolences to all families which have suffered recent bereavements, and in particular the families of the late Mr. Andrew Cummings QC, Mr. Samuel Comijong, barrister at law, former Superintendent Clouston Rogers, particular mention of his spouse, Reverend Lucy Rogers, to the family of the late taxi driver, Mr. Percy Walker, and a special condolences to Jean and to the whole family. The family of Miss Louise Tash, a former senior public officer, who is being laid to rest this very afternoon as I speak. And finally, the family of the late Miss Vida Bulls of Barley, my Barley Anglican School classmate way back in the 1950s. Secondly, I wish to remind you that this is now the 21st year of production of The Law and You. We started in April 1997, so The Law and You is now 21 years old. And I want to thank SVG-TV for having hosted the program, having carried the program free of charge these many years. In the initial stages, there was a fee, but after that, the station has taken over the expenses of the program, and I no longer have to pay broadcasting fees. That is a long time ago. And I want to thank all of you who have encouraged and supported me over the years and wished me well. I just hope that when I depart this earthly scene, or if it comes to the stage where I cannot carry on anymore, that the members of the legal fraternity would carry on the program, and I've already requested the Bar Association not to let The Law and You die when I die, or if I'm unable to continue for one reason or another, I would like the program to be carried on. Now, let me say this to my fellow drivers on the road. I am convinced that the vast majority of drivers are not aware of their obligation when they are driving and approaching a corner and they hear a horn toot. It looks as if the majority of drivers are not aware that they have a responsibility to toot back their horns. So almost every day you're going around a deep bend, you blow your horn several times, there's no answer, and you proceed, and lo and behold, the vehicle is right in the corner, coming at you in the opposite direction. So I want to let drivers know that when you hear the horn of a vehicle and you are going around the corner, you're supposed to toot your horn so that the other driver will know, yes, there is another vehicle approaching. Don't just hear a horn and do nothing and then go around the corner and then all of a sudden you take the driver who had blown his or her horn by surprise. I don't know if there's a question on the written tests they give to people who go for their driving test these days as to what should you do if you're driving around a corner and hear a horn. The answer is you blow yours to say, yes, I am here, because when the other driver blows, he is asking a question, is there anybody coming around this corner? And you're supposed to answer with your horn, yes, I am here, and you blow your horn so that the other driver knows, well, he or she has to proceed with even more caution because of the presence of another vehicle coming in the opposite direction. What is so difficult about that? Very soon I will do a program on noise in vehicles. You see, in the Caribbean, they have got rid of noise in vehicles in, as far as I know, Jamaica, Barbados, Grenada, Trinidad and Tobago, and I don't know of any other islands or countries, but I suppose there are other places where they have succeeded in banning noise being made by music and musical instruments in vehicles, particularly in public service vehicles. I read the newspaper and every now and then I see a letter from somebody complaining about loud noise in vehicles. I happen to have been in a church recently and the pastor was telling me that because the church is right by the roadside, they are disturbed very frequently when vehicles pass with loud noise almost shaking the building. I will deal with that issue in a subsequent program. But for now, let me get on to the topic, the granting of bail. Excuse me. Now, I am sure everybody knows what is bail in criminal procedure. But if you didn't know, bail refers to the setting free of someone who was taken into custody, charged with an offense or offenses, and who is awaiting trial. The opposite of bail is to be remanded in custody. So that very often you hear on the radio or on television or read in the newspapers that so-and-so was charged with this or that offense or offenses and has been granted bail. And on this program, I will explain to you the thinking behind the granting of bail and some of the mechanics of granting bail, so that you'll be a bit more informed about this very important aspect of criminal procedure. The starting point is the Constitution of this country, which prescribes in Section 8, subsection 2, paragraph A, as follows. Every person who is charged with a criminal offense, A, shall be presumed to be innocent until he is proved or has pleaded guilty. I have dealt with this topic on several programs over the years. The presumption of innocence. So that it doesn't matter how many offenses a person had committed in the past and had been sent to jail or fined. Once those offenses have been dealt with and the person has been punished, he could have a long criminal record, a long record of convictions for all sorts of offenses, even including murder. But if that person is taken into custody, is arrested subsequently, and charged with a new offense, the Constitution says that that person has to be presumed to be innocent of that new offense until he has been found guilty or until he has pleaded guilty. So the presumption of innocence applies to every offense with which somebody is charged. The Constitution says that the authorities and all of us have to regard the person charged by the police with an offense as being innocent of that offense until the matter is dealt with in court. So you can't say, oh, this person is a habitual offender and therefore if he is charged, he must be guilty. Don't bother with any trial, just fine him or send him to jail again. No. In every single case, a person accused of having committed a criminal offense is presumed by the Constitution to be innocent until his guilt is established, either by a trial or by he himself admitting to the offense. Now, the philosophy of bail springs from that presumption of innocence. Because if somebody is presumed to be innocent, sorry, yet you keep the person in custody, pending trial, and it takes months for the trial to come off, and at the end of the trial the person is found not guilty, the system would have imprisoned the person innocently. So that we begin by saying that notwithstanding that the police have laid charges against a person, that person is entitled to his or her freedom until the case is heard and determined. Now I'll come to the exceptions, but that is the general philosophy of bail. It is a process by which a man is set free to await his trial. And let me stop saying man or woman, because when I say man, I mean a woman as well. Although compared to men, very few women are charged with criminal offenses. I doubt if they're more than, I think the last figure I heard at the criminal assizes gone by was about 20 or 21 women in custody and over 400 men. Whereas in the population, we have almost equal numbers of men and women, but that is for another discussion. So bail is the process by which, or the giving of bail is the process by which a person is restored to liberty pending the hearing of the case. Now I am going to go to the Criminal Procedure Code and read you the words of the law from section 43 dealing with bail, and if you follow me carefully, I would not have to do much explanation because the law speaks for itself. So here we go. Section 43 of the Criminal Procedure Code, subsection 1. When any person other than a person charged with murder, genocide, high treason, treason, or misprision of treason appears or is brought before a court or is committed for trial by any court and is prepared at any time or at any stage in the proceedings before such court to give bail, such person may, in the discretion of the court, be admitted to bail with or without sureties. Now let me say a few words. The exceptions are the offenses of murder, genocide, high treason, treason or misprision of treason. What those offenses have in common is that they all carry the death penalty. So generally, in death penalty cases, bail is not normally available. Then, pay attention to the phrase, such person may, in the discretion of the court, be admitted to bail with or without sureties. Now, bail is not an absolute right. So that it is always up to the court in every case to decide whether or not to admit someone to bail. But courts cannot discriminate in decision making when it comes to bail. And the practice of the court has to be followed and applied to everybody who comes before the court. So even though a magistrate or a judge has a discretion, that discretion has to be exercised with fairness, with consistency, and without oppression. Therefore, even though the law says that the question of bail is in the discretion of the court, it doesn't mean that a magistrate could come to court one day and say, look, I'm not in the mood to grant anybody bail today. We can't do that. The magistrate has to deal with every case on its own merits, not by whim, not by luck and chance. Subsection 2 of Section 43 of our Criminal Procedure Code reads as follows. The amount of bail in any case to which the provisions of subsection 1 apply shall not be excessive, and any court may, in its discretion, accept a deposit of cash in lieu of giving security, provided that the amount of bail shall not be deemed to be excessive if it is equal to or less than the maximum fine prescribed for any offense with which the applicant has been charged. So, bail cannot be of an excessive amount. Now, I know in the American system, bail is readily granted even for murder cases. But in murder cases, bail is normally set very high, in the millions. In our system, as in the American system, you can be given bail on your own recognizance, that is, you simply sign guaranteeing that you will show up at the trial, or you can be asked to sign for bail in a particular sum, or you can be asked to produce somebody, a person or persons, to sign your bail bond. In other words, to take responsibility for seeing that you will come to court when the case has been set down for. So that when a person is granted bail, normally a date would be given when they have to come back to court for the trial or for further proceedings. And if you get somebody to sign your bail bond for you, that person has the responsibility for making sure that on the day in question, you are presented in court. Otherwise, they might forfeit the amount of the bail. Suppose bail is set in $10,000 for one surety. So a person signs and says, look, if this person doesn't show up for the trial at such and such a date, I will be liable to pay the state $10,000. Sometimes the magistrate may say, $10,000 with two sureties, that is, for two people to take responsibility to sign your bail bond for you. Now, if the morning of the case, and all cases are set down for mornings, you are on bail and you don't show up, those who have signed your bail bond could find themselves in serious trouble. Because the magistrate would say, well, this accused is not here. Who signed the bail bond? And they see the name and address of the person, the sureties, and they send the police with a bench warrant to pick them up and bring them to court to explain to the court why the accused person is not present in court to answer his charge. Now, I'll skip subsection 3 and read you subsection 4. In admitting a person to bail, the court may impose such conditions as it considers appropriate. So, if the court gives a person who is charged with an offense bail, the court can ask him to deposit, and I'm reading subsection 5 now, deposit his passport or other travel document with the court, to report to a police station at some times as may be stipulated, or to confine himself to a specified locality, either generally or between such hours of each day or night as may be specified. So if you are granted bail, the magistrate could say, you're getting bail, but you have to surrender your travel documents. They put stop notices at the ports of departure from St. Vincent and Grenadines. They say you have to report to a certain police station between such and such hours and so many days of the week to make sure that you remain available. Now, you will sometimes hear that the prosecution is objecting to bail. Well, where a person has been taken into custody for wounding or allegedly wounding somebody else, and that person is in hospital, the prosecution normally succeed in persuading the magistrate not to grant bail because they don't know if the person would live or die. If it's a trivial wound, then the accused person's lawyer might be able to persuade the magistrate, look, it's just a laceration and not life-threatening. But if somebody is charged with wounding and the wounding is life-threatening, Normally you will not get bail until the person is out of hospital, and then the court will consider granting bail. So let me round off by saying that one need not be unduly alarmed when one reads or hears about X and Y charged with firearm offenses and got bail, because that is what the law has prescribed. But if they go and commit further offenses when they are on bail, then they're not going to get bail the second time when they're waiting trial for a first offense for which, or previous offense for which they already have been granted bail. And, for example, if the person is charged with an offense, gets bail, and goes and interferes with witnesses, threatening a witness and say, look, if you only come to court, it's me and you, and that is brought to the attention of the magistrate, the bail could be revoked. The magistrate could ask the police to rearrest you, never mind you on bail, and put to you that there has been incredible information that you have been interfering with witnesses. Perhaps they might even call the persons with whom you allege to have interfered with. And if the magistrate is satisfied that you have behaved naughtily when you're on bail, the magistrate could cancel your bail and you go back to jail to await your sentence. Okay? All right, well, that is all for this program of the law, and I hope you understand a little more now about why people are usually put on bail for the offenses. And if you find yourself having committed an offense and awaiting charges and are on bail, please conduct yourself in a very careful manner. Because if you reoffend while you're on bail, crap or smoke your pipe. That is all from this program of The Law and You, program number 896. I look forward to being of further service to you next week, Monday, Divi, for another presentation in this public service nation-building series, The Law and You. Do have a pleasant week, ladies and gentlemen, brothers and sisters, boys and girls, and may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.